Again, physical and sexual abuse, the #1 concern for churches and charities in Canada. Of all of the telephone calls that come into our office, and we have close to 6,000 churches and Christian charities that we insure through our program. So we've got a pretty good cross-section. Of all the calls that come in on questions about coverage, I would say that close to half of the calls relate to the issue of abuse prevention and insurance coverage for abuse to protect the organization and its leaders. It doesn't take too long to read through a paper or to watch media that you don't see another report of alleged abuse. It could be in a church or it could be in a residential institution. But we have cases now that have been coming up, and many have occurred over many, many decades that have come to light in the past 15 to 20 years. And in discussing this issue and understanding it, it's important as Christians to think that we're somehow being singled out or persecuted on this issue, because the fact of the matter is this is an issue that affects any organization that serves young people, that has children in their care. It doesn't matter whether it's a school or a campground, a youth association, or even sports associations. And we've certainly seen plenty of examples of allegations and convictions against coaches in community sports associations. Who's at risk in an abuse claim? Well, certainly infants, young children, teenagers, vulnerable adults. And we've seen claims against organizations related to abuse that's been suffered by all of these categories of individuals. And the law says, and the law holds us responsible for providing a safe environment, particularly for minors. There's certainly child protective agencies that govern this, that oversee it. There is provincial and federal law that requires our standard of care. And in a court case, it is generally held that if you did not show due diligence and care in screening, supervising, handling complaints, that you will be held negligent and legally liable in a court of law for injuries or abuse suffered by minors in your care. And in some ways, it's important to understand that because society's standards have changed, the realities today are much different than they were 30 years ago. 30 years ago or more, allegations against a priest, against a minister, against a teacher, quite often weren't really accepted or believed. They were swept under the carpet. And the arm of the pendulum was at an extreme. And there was a lot of damage that was caused to individuals in society that carried forth into their adult life, into their own relationships with other people if they were victims of abuse, and into their own families. And we're seeing the effects or echoes of that damage today. And now, because of the heightened sensitivity and concern about this issue, the pendulum, of course, has swung the other way. But we are trying to find a balance where we are protecting the children in our care. When we talk about the issue of abuse and relate it to insurance coverage, liability insurance coverage, the proper source of liability coverage for your organization, if you're sued in an abuse claim, is either under the bodily injury section of your General Liability Policy. And I'll make a point here that there are about 180 insurance companies in Canada or sources of coverage that are licensed to write liability insurance. So unlike the banking industry, the insurance industry is quite large and diffuse in terms of its competitors or the number of companies involved, unlike the 6 Schedule A banks that we have. So insurance industry, many insurance companies, but of the 180 companies, there are only a handful today that will even consider writing coverage for abuse. A handful. The rest of the insurance companies have basically said, we exclude all abuse claims. We don't care if you have the best prevention plan in place, coverage is excluded. We consider it a non-insurable event. For the few insurance companies, including ourselves through the Church Protection Plus program, who do offer abuse coverage, and in our case offer it on a very broad basis, you are required to have an abuse prevention plan, which we'll talk about a little bit later in the Safe Place presentation. So sources of coverage, if you've qualified through your general liability insurance under bodily injury, there are some insurers that offer it on a more limited basis, perhaps on a separate policy with a lower amount of coverage, with conditions and exclusions, perhaps on a claims-made basis as well. So the source of coverage for these kinds of claims will be either your general liability if it's covered, or a separate abuse policy. As far as insurance tips about abuse claims, certainly, as I mentioned, a prevention plan is a must to qualify for coverage regardless of which insurance company that you're with. Abuse coverage is better to obtain under an occurrence form policy. We talked a little bit about this earlier on. The reason for that is that it gives you a continuous record of coverage. So even if an abuse allegation comes up many years after the fact, you will always have that policy to go back to if there was coverage there. And if the courts waive the statute of limitations and allow a victim of abuse to sue many years after the fact, that insurance company will have an obligation to respond and pay for the claim. The problem with claims-made coverage relating to abuse incidents is that the companies that do claims-made don't provide any retroactive coverage, unlike directors and officers' liability. So what happens is when you're finished with that company, you move to a new insurance company, you change policies. Under a claims-made abuse policy, they have no further obligation to pay a claim once they're off risk. So there is no retroactive coverage available for abuse claims, unlike a directors and officers policy that does have retroactive coverage. It's important when you're reviewing abuse coverage and your policy to read the fine print for exclusions, conditions, limitations, and sublimits. And again, as mentioned, if you're insured through the Church Protection Plus program and you have qualified for abuse coverage by completing an abuse prevention declaration form and having your particular plan approved, you will have a very broad level of coverage for civil damages, for defense costs. There are even provisions in there for reimbursing individuals that are wrongly accused or falsely accused of abuse. And we will actually pay for the criminal defense costs of those individuals upon acquittal or withdrawal of the charges. And you need to just check your policy for the amount of coverage. Another feature of our policy as well, if you've qualified for abuse coverage, is the provision of voluntary counseling costs, psychotherapy costs. And if a victim comes forward to your organization, says, you know, I was abused by such and such, I don't really want to sue, but I want to see resolution to this. One of the things that the board can offer on a without prejudice, non-admission of liability basis is to reimburse them for their counseling or therapy costs, which is a win-win situation. It's not something that's common in our industry, but we feel it's a good way to respond to these and allow the board to be in a position where even though they don't admit liability, they can still provide a compassionate response.